So I'm giving two talks. First is on Procedure 12, and I'm not going to actually talk about the content of Procedure 12 hardly at all, because it's quite a long document. I'm going to talk more about what's been our experience in using the document, and then quite a bit about what we do as decision makers when an application comes in and we have to evaluate it and decide whether or not we're going to sign off that draft instrument. So that'll be a big focus as well. So some issues with the applications themselves, the application packages, some issues that have come up with the draft instruments themselves. Something called administrative fairness. It's also called procedural fairness. And I wouldn't be surprised if a lot of you have never heard of this before, but it's very important in the world of a government official who's delegated some responsibilities under legislation. And then I want to give you some idea of what happens when I review a draft instrument, just so you know what's going in my head. So here's Procedure 12. Came into effect 1st of April. It's 39 pages long. It's got 5 appendices. It's a lot of information. And I just want to thank you all who submit us draft instruments for memorizing that document already. What does it cover? This is kind of like that very high-level table of contents. When they come in, we screen them, we might reject them. What kind of things must be submitted with applications is important. This document actually says, here are the templates, and it gives an appendix listing all the templates that are used for instruments and covering letters. There's a lot on Schedule B, especially for certificates, and there's a lot on communications and consultation requirements. And you'll see how that last point, how that fits in with these administrative fairness requirements I talked about earlier. Why did we, what are these procedures? They actually are documents that are written for the benefit mainly of ministry staff who have certain duties. And in this case, they're written for decision makers. There's a number of decision makers who sign off the instruments for us. It's also written for people who prepare the draft instruments within our ministry, and that mainly happens with our staff for high-risk sites. And then it's also written for people who process or administer the applications, people like Dave Lockhart. However, since you're preparing these draft instruments for us to sign off, this is also written for you, and there's some sections that deal precisely with approved professional duties and things to think about. So this is directed at approved professionals themselves and at the administrative staff in the CSAP Society offices who process these applications. So let's start talking about some of the issues. That's it for the content of Procedure 12. So who's involved? I mean, what's happening now? For a long time, Doug Walton was the manager in the ministry who processed and signed all the draft instruments. So he's retired, and that was flowed over to Colm Condon for a while, but then Colm went away for 6 months paternity leave, and then that fell to me for 6 months. So for 6 months I was processing and signing all these instruments, and now Colm is back. And how we've decided to divide up the pie is that I will continue to review and sign off the numerical standards type instruments, the determination certificates. Colm would be looking at the risk-based instruments, and then Peggy Evans and Mike McFarlane will continue to do some of the high-risk sites, as well as Colm. And then Lucy Hewlett, who is our client information officer, will continue to be the person who receives the applications and tracks them through our CATS system, it's an access database, and also enters stuff in our precursor database to the site registry. And Dave Lockhart will continue to liaise with me and with Colm in making sure that the draft instruments meet our requirements before we actually review them as a decision maker. Look at those spikes. That's how many determinations of contaminated site we issue every month. And look at these. Look at these spikes. That's how many certificates of compliance we issue every month. So the workload goes up and down all the time. And, it goes from like 5 one month to 35 the next month. So it's quite a challenge for our staff to kind of balance that out. So how's it going with that kind of preliminary statement? How's it going with these approved professional applications? So I can only tell you what I see from my perspective when they come to me. And I think it's going pretty well. There's, I'd say about a third of the things the applications I see, I don't have any comments at all. And the rest, I have a few questions. And normally it takes a day or two to get the answers to my questions. I go back to Dave, what about this? And he phones up and he gets the answer. And many times there's nothing to change at all. It's just my ignorance and I need to understand things a bit better. And then sometimes there truly are things missing and we get that information. Dave, I can't think of one time when I've gone back to you and said there has to be more field work or something like that. I don't recall that happening. Correct me if I'm wrong, Dave, wherever you are. So we have this challenge of the sporadic behavior of the applications. So that's a key challenge for us, and we're working internally to figure out how to smooth that out, and working with Catherine and the board of the CSAP Society to figure out how to make that smoother. One thing, any of you who are submitting applications for instruments to be signed off by us, if you would please use the submissions manager that the Society has created. I understand that just 43% of the submissions to the Society come through that mode. And we feel very strongly from the ministry side it would be a big help if everyone used that. And in my next talk, when I talk about the draft changes to the templates, I'm going to say a little bit more about that. So here's some issues with the applications themselves, the enclosures. Dave has asked me to remind you that we always need both hard copies and electronic copies. So you didn't tell me, Dave, if people aren't doing that, but I assumed they aren't. Otherwise, you wouldn't have me say it. Now, the summary site condition. I get the feeling that I might have changed the way managers and the ministry have been reviewing these applications, but when I get an application, I'll tell you what I'll read first. I always read the summary site condition, and I try to understand what's going on at the site. And I look at the draft instrument together with that summary site condition. So the summary site condition has got to tell me a story that's got to make sense and translate into that draft instrument. And if there's some disconnect or something where I've got a question, then I'm going to go back and say, Dave, why doesn't it say this in the summary site condition, or what's missing? Some of the common things that are missing, or I have questions about, are these vapor attenuation factors. I had one older data. Here was a draft instrument that has substances in Schedule C that weren't even mentioned in the summary site condition. Well, where do these substances come from? Well, it turns out that they were done in earlier reports, and the approved professional felt strongly that those substances shouldn't be mentioned in the summary site condition, but they still could show up on the draft instrument. So I'm tearing with hair left is on my head out because I don't understand this at all. So anyway, the summary site condition should reflect everything in the history, if it's going to be showing up in the certificate or whatever the instrument is. From our side, the summary site condition is somewhat out of date. Things have changed. We've got, I think since it was drafted, we've got vapor standards in Schedule 11, so there's some holes and gaps. So I think you've been asked to provide information on certain types of substances that maybe there's not room for, so you put it in a part of summary site condition where there's little space. So anything you can do to slip in some extra explanations like that is going to be welcomed, because it will take some time for us to amend the summary site condition. We've got some ideas, and I've got some more ideas I just wrote down today. I've also been asked to mention the change in Protocol 6. It still requires that the full extent of contamination be delineated and remediated at sites, but now it's in a form of a pre-approval. We assume that it will be delineated and remediated, and if it's not, then you got to get a pre-approval, and that's in that Table 2 of the Protocol 6. It's the first item in Table 2 of Protocol 6. So just a reminder. And it might be we don't require you to do it, but we have to turn our attention to it first. There has to be good reasons not to do that. So here's some issues with the draft instruments now. Just some things that I've come across, and they're not really common, but they do come up. And the first is the uses of the environmental media. I've seen summaries of site condition and parkland, urban parkland, and residential land uses ticked off as being uses that apply, but when you look at the instrument, there's just one of them. So it's kind of a gap. So we'll wonder, what happened to urban parkland, for example? These water, the water uses are been problematic for me, partly because I don't understand what the words mean sometimes, but in this case, as Amy and Annette said, the no drinking water use ones, we're trying to map out the locations of the sites where that applies. So these get pulled out and given to either Amy or Annette for their review, and then when they're doing the review, sometimes people haven't done it quite correctly. So that's one of the reasons why we had this talk at the end of the morning, to hopefully get people up to a speed on using TG6 correctly. So that takes a little bit of time. It takes about, I'm told, about half a day for staff to have a look at that. They're not getting held up much for that. And then this term, no water use. And to tell you the truth, when I looked at that term, I don't know what it means. So it could mean you can't use the water, or it could mean the water isn't being used. So it's going to take, that wording is in the summary site condition, but for now we're going to change them to no specified water use, and that means no specific water use applies at the site. It could be so. It's not the water use is prohibited meaning; it's the other meaning. Schedule A. Dave asked me to mention this one again. When there's a site location map, you've got to be able to figure out how to drive to the site or ride your bike to the site from that map. And I've seen a few of them that are so bad and so faint that we've had to redo them ourselves. So, please make them so they're legible. It's going to slow your application down if you don't. Another experience I had was there's a creek running through the site. There's a riparian zone that applies, but there were no boundaries saying what the boundaries were of the riparian zone. And of course, the urban parkland standards apply there, and the other uses applied elsewhere. So you couldn't really tell. How can you issue a certificate where there's two different land uses and you don't know what the boundaries are? So my little brain is thinking like that. And then occasionally we get people who apply to combine parcels with different owners into one site. And I've been talking about this for years now, and this first in the site boundaries procedure and then in fact sheet 48. So, those are going to get turned back. We can do that, but there has to be supporting documentation and agreement by all the parcel owners to do that. And it does happen. Kerry, the very first one was in Surrey. I remember that years ago. You're famous in my mind for that. Schedule B, performance verifications plans. In August 2011, we came out with our latest version of the templates for the instruments. And I think those are put in your submissions manager. And we just verified that, and we've been looking at those templates. And they have a requirement for these things called performance verification plans. They're part of the risk-based certificates and the risk-based contaminant management. And I guess what's been happening is we haven't been getting a lot of these plans in a standalone form, but people have been doing it. They've been referring to that kind of plan in a report, like a risk assessment or something like that. So sometimes they haven't been provided, and to tell you the truth, I don't know. Some of those might have slipped by my attention. It's possible. Starting on August 1st this year, we're going to be requiring standalone performance verification plans to be submitted as part of the application package. So you've got a couple of months to get used to that. And in the meantime, we still expect these plans to be given to us, but you can refer to them in a different document if you want. So August 1st to date. So where's Glenn? Have I got that captured? That's right. And Glenn will be talking about that tomorrow. This is mainly an issue for the risk assessors, but others need to know about it. Someone asked, well, does that mean until August 1st that we can disregard what Procedure 12 says about this? No. Procedure 12 is still in effect, and these requirements have been in effect since last August 2011, actually. We've had, of all the things probably I've worked on changing and editing in these draft instruments are these, we used to call them principal risk management controls, and now we call them principal risk controls. And we've are thinking about these as change too. They used to just kind of list some qualities of the site, and now we're seeing they're more to commands like thou must not use the soil for vegetable gardens or something like that. So it's more of a strong requirement than a statement of condition. And then there's been a few issues with vapor clauses. Sometimes there's a standard vapor clause, sometimes it's been missed, and it's kind of confusing. Hopefully we'll be fixing that in the next draft of the templates. Schedule C. Michael, you mentioned this. Sometimes there's issues with NAPL when it's either not listed or is listed, and we've got some items in Procedure 12 about that, and the same applies to hazardous waste. Sometimes I've seen an instrument list hazardous waste when it wasn't necessary. The basic idea is if you know the constituent substances and they're in some of the schedules of the Contaminated Sites Regulation, you need not list NAPL or hazardous waste. Okay, here we go into administrative fairness now. So this is the world of the civil servants. Just so you know, we have a lot of statutory decision makers here because a lot of our staff either have broad powers under Part 4 of the Environmental Management Act to do things like sign instruments, or they can make decisions in certain areas like on ordering site profiles and things like that. So as a general rule, every decision maker in any area in government has some requirements they must follow. And here's a list of them. We have to be neutral people. We can't have biases. I've known some decision makers that didn't have this, weren't particularly neutral, and they suffered because of it. We can't be fettered. We can't do what someone says we have to do. If the minister says you have to make a decision like this under the Environmental Management Act, we don't have to do it. We're independent decision makers. And I don't know if you heard Minister Lake on the radio a few months ago about there's a permit application on around Shawnigan Lake for taking for soils for relocation. And he was very clear, that's up to the regional manager to do that, to make that decision. It's not me at all. So it's politicians. It's a big separation between the politicians and the legal decision makers. Only relevant information. You can't talk. You can't consider extraneous stuff. You have to dismiss that. You have to review it properly. Thank goodness we have almost 100 approved professionals, and we're authorized to rely on your recommendations. Otherwise, we'd be, doing a huge review, and it would take forever to get instruments. And we have to make decisions in a manner that's consistent with previous decisions and the information that we have as a basis for making decisions. And we have to use discretion appropriately. We just can't change our mind whenever we feel like it. So this is all about what's called administrative law. I don't know how many of you have gone to law school, but there's administrative law courses out there that you can take, especially if you think might want to work in government. You can study about how to do this. This is a body of law that's in the common law. You don't see it in a statute, usually. And it talks about not only the procedures for making decisions, but actually the content of the procedures themselves. So I don't have unbounded authority to make decisions in certain areas. There are constraints. And the remedies are the Environmental Appeal Board, for a start. And we, from time to time, get our decisions appealed. And the last important one was when one of us decided not to issue a certificate, and that was appealed. And then if the person doesn't like the decision, then it can go to the Supreme Court. So there's various levels of appeal. The administrative fairness provisions also can be built into statute, and those of you who are involved with the determinations of contaminated site, there's a preliminary and a final determination. And those steps, where you give an opportunity to the people affected to comment, those are strictly administrative fairness requirements. And if these provisions in Section 44 of the Act didn't exist, we still would have to think about administrative fairness provisions. So the fact that they're not written down explicitly for certificates or approvals in principle doesn't matter. We still have to do the administrative fairness requirements. So principles and duties. We have a duty to communicate what we're planning on deciding and consult with the potentially affected parties. And we have to give them information that will help them assess the situation. And then the question is, to what extent do you have to do that? And it depends on the potential impact on the potentially affected parties. If the potential effects are significant, then you've got to do the consultation. But if they're might be trivial or inconsequential or merely an inconvenience, then you might not have to consult. So then once you've done your decision, then you have to give the affected parties, and that's why you see all the CCs and all the covering letters for the instruments. And then once you've made a decision, you just can't change your mind as a decision maker. This is the concept I learned called functus officio. It's quite the term, but it means you just can't go ahead and undo what you've done, and you can make some minor corrections. There's some small technical errors, but we don't have the ability to amend instruments ourselves, basically. So what's the bottom line here in terms of our actual practice? So for determinations of contaminated site, the requirements are built into Section 44. So we always do those, consultations on the preliminary determinations. Now, how about the numerical standard certificates? And I think I can speak for all the managers who sign these things off. These are good news. The site unlikely is contaminated. The possibility of impacts is very low. They're meeting this remediation standards for particular uses. So we don't normally send these to potentially affected parties for consultation. However, for the approvals in principle and the risk-based certificates where there's still contamination around, and there might be ongoing obligations, it could be onerous on parties, Like you're going to have a groundwater treatment plant on your affected parcel, and you're going to have to provide access for the next 20 years so people can change carbon filters or whatever. You're going to have to give those people a chance to weigh in on what they think. So the next question is, well, what's the ministry going to do if they say, well, I don't want it? Well, that's on a case-by-case basis, and the decision makers will have to figure out if this is really fair or not. So it's an interesting world that maybe you don't know about. So when these things come to us, then it's a whole new layer. So the next thing I want to tell you about is what we do, what actually I do. I'm not going to speak for others now, but here's what I do. I get the package from Dave, and I look at the draft instrument in detail, except for the standard clauses, which hopefully should be the same, every time. I don't have to read them over and over again. I read the summary of site condition in great detail. That's the first thing I actually read. I ask Dave to give me the current land title, and I read that in every case because I need to know who the potentially affected parties are, and that's one way of finding out who they are. I print off the details report from the site registry, and I read that. And then I think about other regulatory requirements, whatever they might be. There's other databases we have where I can find that out. That's got some limits. If you haven't paid your fine for a parking ticket, I don't think we can not issue that certificate. So it's more things that I'm concerned about in Part 4. I get some sense of that from the site registry mainly. And then other available information. We might have heard other stuff about the site besides what's in the package I get. So we have to consider that too. Then I've got a checklist that I've created, and I'm going to show you that at the very end. And I go through that. And then depending if I have questions or comments or need more information, I'll go back to Dave and say, Dave, well, what about this and what about that? Where do these substances come from that aren't mentioned in the summary site condition? So he'll get back and he'll sort that out, and then the changes will be made, and I'll sign it off. And that normally takes 1 or 2 days. In the last 2 weeks, I've signed 15 determinations and certificates, so it doesn't take long if they're done correctly. So the last thing is, don't know if you can read that, but this is now draft 13 or so of this checklist that I've made up for myself. And I just want to give you a flavor of the kinds of things I turn my attention to as making this decision. Well, the first section is just, what are they applying for? What kind of instrument? Then the next section is about who owns the land. And it's especially important is, are you applying for an instrument for someone else's land? Because you can do that for a certificate. And are you including that in your site or not? And if you are, then I've got to have I've got to have an email or a letter from the owner of that affected property saying, yeah, I'm good with it. Because you're not, then we're going to need to get separate instruments. Contamination status. I'm going to want to know if it's a high-risk site or not. And I always check, because if it is a high-risk site, I shouldn't be reviewing it. It should be someone else reviewing it in our group, because I'm doing the non-high-risk sites. Remediation status. I'm not going to talk about that. Regulatory requirements. Any outstanding requirements. There's only, if you haven't paid the fees, you don't get your instrument. And there's one other one that I forget what it is. But the nice thing there is you always pay the fees up front, so people aren't going to get caught there. No, I know the other one is if you haven't fulfilled a condition. Say you've had an AIP and there was a condition in it that was required to report to us or whatever, and then you applied for a certificate and you hadn't been following up on that condition, then there might be an issue there. We don't have to issue the instrument then. This is so small. Oh, that's what I want. The land ownership records. That's the land title. So I want to know, that's just a way for me to tick off, yes, I've reviewed the land title. And then the next page is the consultation records. Do I have those if they're required? And the next section is the site registry. Have I seen the site registry report and reviewed it. And then there's an area to do with, well, if we have consulted with people, what did they say and what were their concerns, and then we have to decide if those concerns are valid. And then the last thing is making the decision. And I was going to read this out to you. There's only relevant information being used in making the decision. So I ask myself that each time. Is the decision being made in a manner consistent with previous decisions on similar sites? And is discretion being exercised? And can any inconsistency be justified and explained? So just like we expect you to justify deviations from our guidance and give us rationale, we ourselves have to do the same thing when we make decisions. And I don't know if you've ever seen any remediation orders, but we spend a long time writing up reasons for doing things. You know, it's a very important part of our work. So I think that's the last slide. And I hope that was interesting as something new.
Thank you, John.